Hello and very good morning to all of you. This is Shweta Soni, Assistant Professor from Sage University, Bhopal. Today we are going to discuss a topic, right of the accused person, which is related to constitutional law as well as criminal procedural law. In the very first slide, we are going to discuss who is an accused person. An accused person is an entity who has been alleged to have committed an offense. In criminal matters, an accused person is the one against whom the FIR is registered. Now, what are the rights of the accused? The accused person are also granted certain rights, the most basic of which are found in the Indian Constitution. An accused has certain rights during the course of any investigation, inquiry, or trial of the offense with which he is charged, and he should be protected against arbitrary or illegal arrest. Now, under constitutional law, some of the rights are given. Our constitutional is based on fundamental, that is, let hundreds go unpunished, but never punish an innocent person. According to Article 14 of our Constitution of India, a right to get a fair representation in a criminal procedure is a facet of right of equality. According to Article 20 of the Constitution of India, no person shall be convicted of any offense except for the violation of law in force at the time of the commission of the act charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under law in force at the time of the commission of the offense. According to Article 21 of the Constitution of India, by the judicial voice, a wider ambit has been given to the right to life and liberty, and thus accused are given a human treatment in jails, fulfilling reformative approach. Some of the exceptions to the right is that it is not to be applied on alien. Thereby, these rights under Constitution are inherent right and cannot be altered or changed. Under criminal laws, there are some rights of the accused person at different stages, which includes arrested person during a court trial and after a trial is completed. Firstly, we are going to discuss few of the rights, right to know the grounds of the arrest. According to Section 50, Clause 1 of Criminal Procedural Code, a person arrested without warrant is entitled to know the full particulars of offense for which he is being arrested. Right to have bail. Any person who is arrested without a warrant and is accused of a bailable offense has to be informed by the police officer. It is the duty of the police officer to inform the accused and that he is entitled to be released on bail on payment of the security amount. Thirdly, right to be taken before a magistrate without delay. According to Section 56 and 76 of the Criminal Procedural Code, an accused has to be produced before a magistrate within the 24 hours of the arrest. Right to consult a legal practitioner. The person against whom proceedings are initiated has a right to be defeated by a pleader of his choice. Right of free legal aid. A duty is imposed on all magistrates and courts to inform the indigent accused of his right to get free legal aid. The right to appeal. The right of the arrested person include the right to file an appeal against his conviction in a higher court. In the very next slide, some of the case laws are there, which includes right of the accused person. The most important case law is D.K. Basu versus State of West Bengal, 1997. In this case, Supreme Court issued some of the guidelines which were required to be mandatorily followed in all cases of arrest or detention, which includes the arresting authority should bear accurate, visible, and clear identification along with their name tags with their designation. The memo to be signed by the person arrested and family members, the family or the friend, whosoever the person arrested nominates, must be informed about the arrest of the accused. The person arrested may be permitted to meet his lawyer during interrogation, though does not have the right to be present throughout the interrogation, etc. Now, the most important topic, narcoanalysis, polygraph, and brain mapping, in which one leading case was there, Selvi versus State of Karnataka. The Supreme Court has declared narcoanalysis, polygraph test, and brain mapping unconstitutional and violative of human rights. Another right is their right to have interview with friends, relatives, and lawyers, in which one case is there Dharamveer versus State of Uttar Pradesh. The court directed the state government to allow family members to visit the prisoners and for the prisoners at least once a year to visit their families under guarded conditions. Thank you very much. I hope this video will be helpful for you. Thank you so much.